Good morning. We are thrilled to have you join us today at the 15th edition of the Global IP Convention. A very warm welcome with open heart and open mind to our chief guests, speakers, and delegates gathered here. Your presence makes this day truly special, and we feel privileged to hold this event. The theme of this year is Innovate, Protect, Scale. Global IP Convention is an annual flagship event that brings together in-house IP councils, innovators, and IP attorneys from around the globe to discuss best practices and solutions for maximizing the value of innovation and intellectual property. GIPC, which lays its foundation in 2009 with just 100 people in a room, today hosting over 4,000 delegates and esteemed panel of speakers participating together for better learning and networking. Sir, now I request all the dignitaries, Shri Rajarshi Gupta, Managing Director and CEO, ONGC Videsh Limited, Navratna CPSC, Professor Dr. Heinz Goddar, Senior Partner, Boehmert and Boehmert, Shri Hari Subramaniam, Managing Director, Subramaniam and Associates. He is the President of APAA also. Shri Pravin Anand, Managing Partner, Anand and Anand. Shri V. Lakshmikumaran, Founder and Managing Partner, Lakshmikumaran and Sridharan, Attorneys. Shri Hemant Singh, President AIPPI India Group. I would request Dr. Dhanpat Agarwal to welcome everybody on the dais, please. Thank you, Dr. Agarwal. Before we formally start the program, we offer our prayers to Lord Ganesha with the invocation song. ज्ञान और समृद्धि का प्रतीक माना जाता है और इसकी रोशनी स्पष्टता और मार्गदर्शन करती है. With this, I would request all the dignitaries to lighten the lamp, please. Thank you, sir and madam. Now there's a time to welcome all our esteemed guests. For this, I would request Dr. Ashwini, Strategy IP Attorney ITech, to welcome Dr. Anita Sumanth with Angwas and memento, please. Thank you, Dr. Ashwini. Now I request Shri Ramesh Ganpati ji to welcome Justice C. Saravanan ji. Thank you, Mr. Ramesh. Now I would request Dr. Venkat Reddy to welcome Shri Rajarshi Gupta, MD ONGC Videsh, please. Thank you, Dr. Venkat. Now I would request Ms. Monica Gupta to welcome Professor Dr. Heinz, please. Thank you, Ms. Monica. Now I will request Mr. Makanam Karabu from the Karimon to welcome Hari Subramaniam ji, please. Thank you, Mr. Karabu. Now I would request Mr. Phillips Abraham to welcome Pravin Anand ji, please. Thank you, Mr. Phillips. Now I would request Dr. Ashwini to welcome V. Lakshmikumaran ji, please. Thank you, Dr. Ashwini. Now I would request Ms. Monica Gupta to welcome Shri Hemant Singh ji, please. Thank you, Monica. Now I will take the privilege to welcome Dr. Dhanpat Agarwal myself. Thank you, everyone. With this, I would request Dr. Dhanpat Agarwal, Founder Director, Global IP Convention and Founder, Trustee of Institute of International Trade, to deliver the welcome address.
Namaskar, Suprabhatam, and good morning. On behalf of Global IP Convention, 15th edition, I welcome all the learned dignitaries from more than 21 countries to share their knowledge and encourage the organizing team to continue its effort in creating awareness and for making IP ecosystem stronger so that the benefit of the knowledge is disseminated to the entire global community. Honorable Justice Dr. Anita, Sumanth, very respected Judge, Madras High Court, Mr. Justice C. Saravanan, Honorable Judge, Madras High Court, Mr. Rajarshi Gupta, Managing Director, ONGC Videsh Limited, Professor Dr. Heinz Goddar, Senior Partner, Boehmert and Boehmert, Munich, Germany, Mr. Subramaniam, Founding and Managing Partner, Subramaniam and Associates, Mr. Pravin Anand, Managing Partner, Anand and Anand, Mr. V. Lakshmikumaran, Managing Partner, Lakshmikumaran and Sridharan, Mr. Hemant Singh, a very prominent advocate and President AIPPI India Group, and all the dear delegates and distinguished speakers. I have the privilege and the pleasure to welcome all of you at this 15th edition of GIPC. We started our journey in the year 2009, and as the Indian philosophy gives us inspiration, Charaiveti, Charaiveti. Keep moving, keep moving. And with that idea, we are moving in our path, and with the cooperation of all of you from year to year. Friends, I believe that in the present era of knowledge, technology, and innovation, it is very important that we look for more and more research, more and more inventions, and more innovation. The theme of this 15th edition is Innovate, Protect, and Scale Up. When I say innovation, I mean innovation is an inclusive term which relates to the new ideas to be implemented at the ground level and not only limited to the scientific invention. Innovation is in all the sphere of life, and for a business organization, it extends its scope to marketing, to finance, to production, and in all the fields, so that to meet the fundamental principles of economics, to allocate the limited resources for its optimum uses, so that there is minimum wastage and maximum output. Friends, we know how much role the IP and innovation plays in the present economic world. If you look at the global income around the world, what we find is that today United States has the highest number in the global GDP. That is $26.5 trillion in the year 2023. But out of that, almost around $7.7 trillion comes only from the IP intensive industry. And that is, friend, more than 34% of the GDP of United States. When we look at other countries, then I find that there is a direct relationship between IP and innovation and the scale of the national income of those countries. Say, for example, China. In 1980, the economy of China was just about $300 billion. And today, Chinese economy is more than $19 trillion, which is the second highest in the world. But the secret is, if you look at the number of patents filed by China today, as per the latest WIPO report, there are almost around 35 lakhs patents filed globally, of which nearly 16 lakh patents are filed only by China alone. So, it is not that in the last 40 years China has grown just by chance. It's not. It is through their gradual and consistent effort that they have been growing, and their economy is the second highest in the world. And when we look at the purchasing power parity, then China becomes number 1. US is number 2, and then of course India is number 3. But today, on the basis of the exchange rate, India's position in the global economy is number 5th. But we must correlate it with the population of a country and the national income of that country. Now, just for example, US population is about 350 million, that is 35 crores, which is around 5% of the global population. But when we look at the GDP of United States, which is $26.5 trillion, that is nearly 25% of the global economy, whose aggregate size is $105 trillion. So it is due to continuous innovation in IP in the United States that is taking that economy up and up throughout what we have been observing. Now, on the other hand, India, where the population is 1400 million, 145 crores nearly, and which is nearly 18% of the global population. But when we look at India's GDP, though it is number 5th in the world, but the percentage which India shares in the global economy is only 3.5%, because India's economy is $3.7 trillion. So when we conceive of Bharat 2047, then we have to look at how this economic growth can happen. I believe that this economic growth cannot happen without looking into the very crux of the secret, that is IP and innovation. The population which we have is, of course, a very rich human resource. We are the youngest country in the world. We also speak about the demographic dividend, but we have to educate our people. We have to develop the skill of the people. We have to have a very strong research and development institutions. When we look at China, they spend nearly 2.5% of their GDP into research and development. When we look at United States, there also we find they spend nearly 2% of their GDP in the R&D. When we look at India, we spend hardly 0.67% of our GDP into R&D. So, with this idea, the purpose of this conference, where we have the talents from all over the country and from more than 20 countries. In 2 days, we will discuss on various aspects of the intellectual property, on various types of technology, be it automobiles, be it electrical, be it artificial intelligence, be it pharma, be it biotechnology, all the fields and from different dimensions, about the technicalities involved in patenting and the patentability. So I hope in our this Jnana Yajna, we will have the benefit of the knowledge and the talent you people have, and in 2 days deliberations, when we go from here, I feel we will be more enlightened and with more knowledge and vigor, because knowledge is capital, knowledge is power. So therefore, I feel that my friends from Cameroon, Tanzania, Ethiopia, and USA, Europe, many countries, Germany, UK, and several other countries. I have my friend here from Japan, Hattori-san, whom I know for a very long time. And I have my very senior knowledgeable persons sitting here, Professor Prabhuda Ganguly, and many, many. And I hope that the cooperation which I have been receiving from all the dignitaries sitting here, Professor Heinz Goddar, he has been coming to this conference since almost beginning. I think Mr. Ladlu, he is from Canada, he is here somewhere. So we have been, I am proud to say that he has been coming to this GIPC consistently for almost 13, 14 years. So the kind of support I receive, please excuse me if I have not been able to name many persons because it's a collective cooperation and coordination and the efforts of all the people. And my dear sisters, Dr. Ashwini and Nisa and all the people and our event management team, I really acknowledge my thanks to everybody, and I hope that this conference will be another stepping stone in our efforts to make our IP ecosystem stronger gradually, day by day. With these words, I conclude my thoughts. Thank you very much.
Thank you, Dr. Agarwal. We really appreciate your thoughts and efforts on overall development of our economy. So now the time is there to hear from all our distinguished guests. I will welcome Shri Hari Subramaniam, Managing Director, Subramaniam and Associates, to share their views with us.
Good morning. It's so heartening to see so many people on a Sunday morning on a cold winter. When I spoke for the first time, that was way back in 1982, when people did not know what intellectual property was. I was speaking in a seminar organized by CSIR. There were 14 people, 9 out of which were sitting on the dais. And we had a hall which was meant for 100 people. We went to the seminar, and it was otherwise a very salubrious day. We have come a long way in the last 40 years that I've been in the profession. But it's my real privilege here today to sit alongside two sitting judges of the Chennai High Court, Justice Saravanan, Justice Sumanth, and some of the most brilliant and leading IP brains from the world, Pravin, Anand, Heinz Singh, Lakshmikumaran, and then, of course, I have seen Rajarshi. I've heard his name, but I have not had an opportunity to work with him. And Professor Heinz Goddar, I worked with him. We have conducted teaching workshops many times. These are the people sitting here today who are really responsible for where the IP ecosystem is in India today at this point of time. I remember 1981 when I started this profession. I was still prosecuting patent applications filed under the 1911 Act, but being examined under the 1970 Act. So those were the days when the patent application would be examined, and before we could file our response, the term of the patent would expire. And there was absolutely no way one could really get a sensible IP protection in India. Sometimes clients always used to wonder, why do we even file patent applications or trademark applications or any IP protection in India? India wasn't really a first choice for anybody to apply for intellectual property rights, except for the fact that it had a huge potential market, but the protection itself was very, very weak. One of the most important reasons why they actually tried to seek protection in India was it was very cheap, it was cost effective. We had practically no IP enforcements, no litigation. Most of the IP provisions, which were often incorrectly interpreted by the IP officers, were not really set right by the courts because hardly any matter went to the court. But the situation changed from 1981 when I joined the profession. By the time it was 1990, we had some amazing judgments on IP. Things like a Gillette defense, Norwich Pharmacol, Anton Pillar order. These were the things which are heard in textbooks in UK and the US, etc. They became a reality in India thanks to people like Pravin Anand sitting here, Heinz Singh. They all brought such new outside developed countries concepts into India, and the courts, of course, were very, very receptive to this evolution in law and were ready to apply them to Indian law as well and correctly interpret the Indian provisions. On copyright, on trademark, we had some amazing judgments from the courts. And often, many of them are being cited in other countries of the world. Our law has undergone several changes. There was a time when we had a product patent regime in 1911 under Patents Act. We had a 16-year term. Then in 1970, it became a 7-year term for process patents and no product patents in India at all for chemical and pharmaceuticals. And came 2005, we came back to product patents, and now we have a proper product patent regime with 20 years term, but the problem is in the enforcement. We have what we call inbuilt safeguards in the Patents Act to make sure that the rights holder does not abuse their intellectual property. But unfortunately, often those safeguards are misused as well. So we have a system here, we are in a situation at this point of time in an attempt to balance rights between the public and the innovators. Sometimes I wonder whether we are actually more loaded in favor of the public and less in favor of innovator. If you look at the history, innovators have often, and well, not often I would say, but tend to abuse their rights, and you need the checks and balances. But at the same time, to discourage innovations, to have laws which discourage innovations is counterproductive. And we need to set that right. I know that our courts are valiantly trying to balance the rights between the innovators and the public, but we still have a long way to go. We have had several progress made in our IP regime in the last few years. For first time in history, we have had a IP division in the Delhi High Court. It took us a long time to set up that. I was very privileged to make a minuscule contribution in that and drafting the early rules for this. We're delighted that the Chennai High Court also has an IP division. Unfortunately, Mumbai High Court does not have, and the Mumbai and Calcutta High Court, we still have to wait for a long time before the justice is delivered as far as IP cases are concerned. But we are going there, but sometimes I wonder whether we are going fast enough. There's a long way to go, and we talk about it all the time, and we try our best to do things right, but I think we need to move a little faster. I really won't want to take too much of time here because I'm more curious to hear some of the much more experienced and much more highly knowledgeable speakers sitting over here, and I'm conscious of the time factor. So thank you very much for all of you for being here, and have a great seminar today. Thank you.
Thank you very much, sir, for giving the insight into the phase of development of IP acts and provisions. We really appreciate your efforts. With this, I would request Shri Rajarshi Gupta, Managing Director and CEO, ONGC Videsh, to share his views, please.
A very good morning. Distinguished guests on the dais, esteemed speakers, innovators, and IP experts. It is indeed a great privilege here to be with you today, and I am in the company of so many luminaries. We have heard about them, seen them, used their opinion for so many of our industry cases that it is really good to have a face-to-face interaction with all of you. The two justices and the lawyers, the experts. I would first of all like to thank the organizers of the 15th Global IP Convention for inviting me to this gathering. As we have heard that GIPC down the years has emerged as the premier platform of minds where innovation meets inspiration, where protection fuels progress, and scalability unlocks boundless possibilities. And I am again feeling privileged to be here today. The good gathering here on a, like the previous speaker said, on a winter morning in Delhi is very encouraging. As a professional from the energy industry, we are seeing a lot of volatility. We are looking at transition. We are also looking at more and more collaboration in our world. Our is a knowledge-intensive industry, a technology-intensive industry, and as we go forward, as we encourage different energy sources to compete with each other and be more sustainable, it is imperative that innovations and innovators are encouraged. And also, we need to, as we collaborate more, cooperate more, we also need to protect them more. Only then we'll see better innovations and getting ahead of the curve, as we say, because the maxim today is you have to do more with less. A shale oil rig well in US was costing 12 million, using so much of energy and propellants, can now be done in 4.5 million. How? Because the innovators thought something differently. Because the young minds decided to challenge the status quo. And these things are now being adopted down the line. But yes, we will always need to encourage and protect these guys who did it first. This year, under the theme Innovate, Protect, Scale, I am sure that this gathering will brainstorm on the IP and its future with the country's vision, that's India's vision, and will guide us through the ever-transforming landscape of IP. As common citizens, we have witnessed breakthroughs in technology, paradigm shifts in legal frameworks, encouraging judgments are coming in, and the rise of new industries which were not there a few years back. And all of this is again fueled by new minds challenging and innovating. But one thing remains paramount everywhere, and that is the impact of intellectual property. I had a stint in the US in Houston in our subsidiary there for 4 years, and I could understand that the US strives on protecting the intellectual property rights. We at this juncture are also of hearing so much about AI, ChatGPT. The future is exciting, and each technology complementing and competing with each other, yet very different, by having its own unique evolution. Along with growth of known techs, new techs are taking shape at every corner of the world today. Who would imagine the impact of ChatGPT a few years back, what's happening in the campuses today? But now these are altering our lives, the way we look at things. Many professions are coming up and many professions are disappearing, forcing us to thinking in different ways. Some of this will definitely change the world as we look at it today. And as a layman in the IP field, I can tell you that IP needs to be relooked, prioritized to maximize its benefits for the stakeholders and for the industry and for the country as a whole. What could be more apt platform than GIPC, where global experts can collaborate and share ideas to deliberate? This year's theme resonates with us in our industry too, where there is an urgent need for protection and scaling up. For a country like India, which has unsatiable appetite for energy, which is one of the largest growing economies in the world, we need to constantly bring up new people, new ideas, new industries, and protect them and ensure that they contribute to the growth of the country. ONGC Videsh today in 15 countries and 3 business centers, total 18 countries, 32 projects. We grapple with this all the time. We are there in Colombia, we are there in Brazil, we are there in Venezuela, we are there in Sudan, we are there in Vietnam, Myanmar. So this challenge of the IP protection in different parts of the world, and then from learning from them and bringing it back to India, is what we look forward to our journey. At GIPC, I gather that it's not just experts, it's a group of like-minded individuals, people who come to learn from the best, who network with the brightest, forge partnerships that will power the next wave of innovations. I do strongly believe that over the next 2 days, delegates and eminent panelists will delve into the intricacies of patents, copyrights, and explore the frontiers of this management. I once again extend my sincere gratitude to the organizer for creating this inclusive space and growing stronger every day, encouraging each other and every one of these delegates to actively participate, share insights, and contribute to the trove of knowledge that will emerge from these discussions. The diversity of perspectives in this room is the greatest strength, and the collaboration that comes from it. All of us, we need to navigate the complexities of the intellectual property landscape, and this is the best forum that we can do it. Thank you so much. Thank you.
Thank you very much, sir. We really appreciate your words of wisdom with linkage of niche of the IP in the today's corporate world. With this, I would request now Shri Hemant Singh ji to please share their words of wisdom with us.
Good morning, members, distinguished members on the dais, distinguished members in the audience. It's a privilege to be here in this such a significant global IP convention organized by Dr. Agarwal. I would like to compliment and congratulate Dr. Agarwal for his continued passion in the field of IP, which has enabled him to organize this conference year after year, and I believe it's a 15th edition. I'm organizing as AIPPI President of India Group a small conference in Bangalore on Tuesday, 9th. And believe you me, I've really gone overboard in terms of my time and effort to just put that small conference together. I wonder how Dr. Agarwal pulls up this kind of a conference year after year at such a large scale. So heartiest congratulations and compliments to you. I believe what drives Dr. Agarwal can also drive all of us and can drive India as a nation to achieve what the theme and the topic is today, that is innovate, protect, and scale up. Very often I wonder why India has lagged behind in achieving that scale of innovation. What is it that we lack? I think we have the greatest of minds. India was, as we all know historically, known as Sone ki Chidiya, which is bird of gold. There used to be, we were told, a river of milk which used to flow. If you look at our mythology, the scripts, it talks about, Ramayana talks about Pushpak Viman, which is, used to fly when nobody had ever heard of flying. I don't think it was a figment of imagination. A bit of it already there. Zero was invented by India. So why is it that we were in the leadership position when it was about innovation, have lagged behind so much now? It was revelation to hear Dr. Agarwal in terms of the statistics which he gave, that we are 18% of global population with only 3.5% of GDP, whereas US is 5% of global population and 25% of GDP. It is something to be really thought about. And I think that when I think about it, I believe perhaps there are only two things. One, either we do not still have absorbed and understood the value of innovation. And because of that, I believe that passion to innovate is lacking. Now, why is it that we haven't understood the value of innovation? Is it because we get things too easy to just replicate? Why there are no innovative drugs coming from the pharmacy of the world, which India is? Why is it that we are all the time fighting to protect innovative drugs in the court of law, as if, if you have innovated a drug, you have committed a kind of a sin? If you go to enforce a patent in relation to an innovative drug, it's a challenge to get an injunction. We are faced with provisions like Section 3D we are accused of evergreening, and there are talks of public interest as to why there should be injunction against drugs which are life-saving drugs. The question is, if you do not protect innovative drugs, why would anyone invest in such innovation? If you are going to get all the innovative drugs easily, why would anyone invest in the R&D? I think that the mindset has to change. And the mindset will only change if it becomes a culture in this country that innovation will be protected at any cost. And if there has to be a shift in terms of what is the public interest is in protecting patents and not in allowing infringements. Section 3D is very good. I'm not at the moment saying anything about it. I have my personal reservation why we need Section 3D when the whole world doesn't have Section 3D. Isn't it good enough that you have a novel and innovative drug? Why there has to be an onerous additional burden to establish enhanced therapeutic efficacy? But be it whatever, at least what we can do as court of law is to not make it difficult for an innovator to establish enhanced efficacy. Jurisprudentially, at least the parameters may be made more reasonable as compared to what they are today, where it is extremely challenging to establish enhanced therapeutic efficacy. I would hope, going forward, that this mindset, this culture change, so that the message which goes from this country is, you are welcome with your innovation because your innovation will be protected. The message which goes to everyone globally is that in India, the focus has shifted. There is a huge now more investment in R&D. There are innovative drugs coming out from the Indian pharma industry. That will be the day when we will be able to say, we have arrived. I believe till then, we are still talking theoretically, but we are somewhere not able to translate into our goal that we have, as we have for India here. In terms of policy, of course, there is a lot of shift. You have our own Prime Minister talking about intellectual property, which is so heartening, that the awareness and the value of IP is perceptible at the highest level. And that has led to, of course, the national IPR policy as way back as 2016, but the implementation of that policy still has not been as effective as it could have been. The enforcement remains a challenge. The piracy level has not gone down. We need to introspect, why is it so? Why the enforcement has really not taken place? We have IPD, which has been constituted, which is a major step forward. I think as an IP fraternity, we have been asking for it for a very long time. Fortunately, it has happened now. And we have one of our own members from the IP fraternity, Justice Pratibha, saying, we need to thank her for this, for having taken that initiative and having constituted the IPT. But we still find that the advantage of that IPT is limited to Delhi. And now, of course, we have had excellent proceedings happening in Chennai. But Ahmedabad, Mumbai, Calcutta, we still have problems. I will hope that that is some focus on IPD being created in those jurisdictions as well. We also need to discuss and understand and find resolution in terms of the new challenges which are coming up, which is AI-generated inventions. How are we going to cope up with generative AI, which is going to impact all of us beyond IP? How are we going to make resolutions in terms of the challenges that AI is going to throw up between the human inventor and a machine inventor? What is going to be the manner to protect the data which is going to be used in generation of these AI-generated inventions? Is that data usage going to be a fair use or infringement? What are going to be the parameters? How are we going to judge the inventive step or non-obviousness in case of AI-generated inventions? These are all major issues which are going to come up and we need to discuss and debate. And I believe this kind of forum is the best forum to raise, discuss, debate such issues and hopefully come out with resolutions which you may then present as a major aid to the government of what it can be in terms of the resolutions. There's a lot to talk about. I'm sure we will be discussing it through the session. But for the time being, that's all I have to say. And I thank Dr. Agarwal once again for this opportunity. Thank you very much.
Thank you, sir, for your deep, valuable ideas on the subject. With this, I would request Professor Dr. Heinz Goddar to please give his brief view on the subject.
Yeah, thank you so much. Good morning, ladies and gentlemen, dear Dr. Dhanpat Agarwal, dear justices, dear colleagues, dear friends. I hope I can include everybody into this category of being my friends. I would like to comment on one thing. And it's a particular pleasure for me that I can follow the president of AIPPI India in this regard. When I was president of LAS International in the late 90s, we had some kind of a work sharing between AIPPI International and LAS International. I was on the LAS side. We created the AIPPI forum idea and said, your work, dear AIPPI, as an NGO, thus the counterpart to WIPO, is to make sure that we get good, strong intellectual property rights, can enforce them, can use them to exclude others, to protect investment into R&D and to create innovation. LAS task is different, namely to commercialize, somehow to use these patents once obtained as a business instrument to share with others, taking Article 7 TRIPS very seriously. And it is a fruitful cooperation between these two organizations since then, ongoing. I would like, not being an economist, but with my past as an international past president of LASI and still active in this field a lot, to focus on one thing which is very often forgotten or not emphasized sufficiently when talking about the value of patents. Of course, they are there to protect, after soliciting investment into R&D, your innovation against unauthorized use by others. Of course, and particularly this idea is taken very, very seriously in India, as long as I know about, since 96, 97, the rapid development of intellectual property and patent consciousness in India. That is to share Article 7 TRIPS, to consider patents as an offer to mankind. The more patents, the more offers to share the innovation once protected. Fine, I don't talk about this. But one aspect is not sufficiently, I think, taken into consideration, particularly in India, when I compare it with China, where I have had the honor to participate in the creation of the Chinese patent law since 1981 on behalf of the German Patent Office, who assisted China a little bit, let's say, into the coming into existence of Chinese patent law, which factually even today looks for me very, very German. And this is, when you come to Chinese companies nowadays, they don't consider fees, money to be spent into get patents as expenditure anymore. They are not cost. They are investments into a different currency, namely into patents which you need to have the ability by cross-licensing to pay for licenses from others. The more patents you have, the less you have to pay in cash if you, and this is inevitable for an innovative company, whether it is in pharma, whether it is particularly in ICT, when you need to use other patents. If you come there and say, I wish a license, the Qualcomms of this world, the Ericssons, the Nokias, all dear friends, they will say, oh yeah, wonderful, we give you a license. By the way, by which currency do you pay? Chinese yen, US dollars, Indian rupees, whatsoever. No, actually we don't like these currencies too much. We like cross-licenses under your patents. The more cross-licenses you can give to us, less in cash you have to pay. Maybe even nothing you have to pay. Maybe we must pay something to you. So this consciousness that patents actually have a value as a different currency to obtain freedom to operate from others whose patents you need to use. And this is a call now upon all the politically very influential participants in these conferences of Dr. Agarwal all the time, from patent office to ministries and you name it, and big companies like we have them today here. It is that we need to find some way how to show the intellectual property created, particularly patents, by investment into R&D in the balance sheet, in the business report. At least in Europe, in the United States, we everywhere have the problem. China is starting to improve it so far that we cannot activate, as we call it, in the financial business, self-created intellectual property and patents in your balance sheet. This is the reason for this big discrepancy between the market capitalization value of a company, of a public company, and what you see in the business report. And I would like to see a possibility that this can be shown in balance sheets, which needs, and this is my last word insofar, an action by the legislator. It needs that we create a accepted, generally accepted, I would say, valuation authority or institution which puts a price tag, a monetary tag to each and every patent in a reliable, in a credible, in a generally accepted manner, and all of a sudden the balance sheets, what is published, will look much more similar to what the exchange values of certain companies show. Last but not least, unsolved, what do we do with the trade secrets? Trade secret protection is becoming more and more important. What I believe is, and we have talked about this with many friends here in India since a while already, why don't we have a depository for trade secrets, blockchain secured, where somebody who has knowledge, data, whatever, to supplement patent protection, puts the trade secret, it is under secrecy, and access can be given, maybe against a fair additional royalty if it is on a contractual basis, maybe even to be included in compulsory licensing and regulator authorities where these trade secrets are there, and if you wish to not only be allowed to use patents, you can go there, get access to these trade secrets, and then also the trade secrets become, by such an accessible depository, a vehicle for technology transfer. Thank you so much. That was all for today. We have a lot to think about.
Thank you, Dr. Heinz. We really appreciate deep insight to the value of patents you have given to us. I would now request Shri Pravin Anandji to share his views.
Honorable judges, distinguished panelists, we have been talking with the mindset that innovation in the field of science and technology is essentially what innovation is all about, at least in our context. I think that's quite true, but innovation is not restricted to science and technology. We have a huge amount of social innovation. We have, for example, educational platforms like Khan Academy, which may have, some of you may have used. I don't think it's Indian, it's international and very, very, very successful. We have microfinance institutions like Grameen Bank. We have sharing platforms like Airbnb and Uber.
So also in the IP world, there are lots of non-technical innovations. And today, I will just give a few comments on what I consider to be a very important aspect of innovation in the field of dispute resolution. In the field of dispute resolution, right after COVID, we developed the hybrid system whereby clients and witnesses almost from all over the world could participate in proceedings, saving a lot of time, and matters proceeded very rapidly forward. I think that was an extremely innovative thing, appears to be small, but had a huge impact, and I compared with a lot of countries that did not have a similar system. We had practices. In the past, we've had a judge who, when he saw a rogue defendant trying to address arguments and then run away, waiting for a roster change so that he gets a more favorable judge, he would capture the matter with himself by asking the parties to dictate their propositions in court. And so the matter would become firmly embedded in that court and become a part-heard matter, and thereby a rogue defendant who tried to run away could not do so. We have a present sitting judge who follows the practice of, at the end of a partial argument of the day, of dictating what was argued by both the parties that very moment, so that it becomes already a part-heard judgment. It's partly dictated judgment. We have several other practices, such as the Supreme Court saying that now it is time for time slots to be given, or time limits on arguments, 1 hour each side, 20 minutes each side. Note of arguments not exceeding 5 pages, not exceeding 3 pages. And of course, some judges, not all, some judges following a practice of, in a standard case where 5 injunctions have already been granted, and this is the 6th one coming up with similar facts, allowing the party to bring, the plaintiff, to bring a draft order so that the judge doesn't waste 20 minutes dictating the order in court, but simply adding a few paragraphs, having a look at the draft order, and in 5 minutes disposing of the case. Because in the context of a legal proceedings, a hearing of the day, that 5 hours or so in court with the 1 hour lunch breaks is public time. And that public time has to be shared with all the litigants. I think it's most unfair if 1 or 2 matters consume the whole day, leaving all the others to be taken 2 months, 3 months later after an adjournment at the end of the day. So therefore, how a judge divides that time effectively, some of these practices relate to that. And they've been most unusual. Then, remedies. We started off with the unique remedies of Anton Pillar orders, Mariva injunctions, etc., etc. There have been some very unique remedies which have been granted. The tree order of the Delhi High Court, where the defendant was unable to pay, but the defendant was asked to plant 140,000 trees in the central ridge area of Delhi, and the plaintiff would get CSR benefit from that money. So it was a win-win-win. The defendant was made to pay, the plaintiff got CSR benefit, and the public got some sort of pollution control measures. Or orders where defendants who were unable to pay were directed to to perform community service at an orphanage or an old home, or Justice Sikri's spittoon order in a Baba Zarda case, where the defendant, unable to pay, was asked to install 300 spittoons, being a chewing tobacco case, 300 spittoons in the Osmania Hospital in Hyderabad, or a case relating to eyeglasses, Ray-Ban counterfeits. The defendant was asked to file a large number of dark glasses with several blind institutes. Or an Hermes order, where the defendant was asked to supply sanitary napkins for adolescent girls in 11 schools in Delhi, because they could not afford that. Now, the injunctions also have undergone change. Now, in the Unwired Planet case in England, you had the FRAND injunction, which means in a standard essential patent case, if the defendant is unwilling to take a global license on the terms decided by the court, then there would be a UK injunction. So it was a totally different injunction from normal ones, called a FRAND injunction. Or recently, a few days ago, the newcomer injunction. This is the latest form of injunction in England, where against gypsies and travelers, an injunction was granted from squatting on government land, even though there was no risk or apprehension, and it was totally qua timid before they did anything wrong. So a newcomer injunction was the newest form of injunctions. As the Supreme Court in England said that there is a need for flexibility, that you don't have to prove a prima facie case in these newcomer injunctions. A third aspect is time reduction. And we've had the Commercial Courts Act, we've had all sorts of measures which have reduced time, but some of the practices adopted by some judges, like reversal of burden of proof. For example, if validity of a patent is not challenged, the issues are so framed that the evidence starts off with the defendant leading evidence first, which saves a lot of time. And the result of all these practices cumulatively is that we've had a disposal of orders passed effectively in 450 cases since the Intellectual Property Division was set up in Delhi. And I think this is the way forward in terms of innovation. And when we talk of scaling, this needs to be spread to a lot of the other courts in the country, and that's how we'll achieve quick dispute resolution. Thank you.
Thank you, Pravin sir. It was good to hear from you on the subject. With this, I would request Shri V. Lakshmikumaran ji to come and share his views.
My Ladyship Anita, and I will be privileged to address Mr. Saravanan as my Lord Justice Saravanan, and my friend Ganpati and all my friends. I've already been warned that the time is up, I should reduce my talk. I think they know that I love my own voice, I talk longer. That is why they rationed my time. I respect that, no problem. We heard the speakers talking about the way the protection has to be given, the way the economy can grow when you have IPR protection properly done. We heard all those things. And there is also a correlation between the increase in GDP and the grant of or protecting the IPRs. We all know that. I must also say what is applicable to the US or to Germany or to England or Israel need not necessarily apply as such to India. India has its own peculiar ways of running this country. We have a different population. Many people are below the poverty line. Leave alone this. Once India signed the TRIPS agreement as part of WTO in 1995, with reservations and with various types of times for implementation, India did implement. We must ask a question to all of us, the sitting here. What were the aspirations and mindset of people in 1995, Indian people, when India signed the TRIPS agreement? And what is the aspiration and what is the mindset of people today in 2024? There is a paradigm shift. That was a time when we felt that with the grant of patents and other IPRs, there will be exploitation of Indian population. And therefore, we were trying to say, don't do this, I will not give this patent for this, I will not give it, etc. Or section 3D, 3K, etc. are the results of that particular mindset. That is on the substantial portion of law. There is a procedural side of this law. Pre-grant oppositions, post-grant oppositions, revocations, endless limits of filing pre-grant oppositions again and again till the almost end of the patent's time. That is on the procedural side. And I think probably India is the only country in the world which grants a mandatory hearing for a pre-grant opposition. No other country does it. All these things are happening. And therefore, there is a lot of frustration on the part of the innovators. But the innovators need not necessarily from outside. Today you go to the Bangalore or to Gurgaon and other places where innovators are there. When they ask a question to me, sir, can I get a patent on this? When I say, you can't get it in India, but you can get it in the US or in the Europe. It doesn't look nice. It doesn't look nice. I think time has come when all of us, the people sitting here and sitting outside, should sit in a room and discuss, hey, what we want now? Is it what we want to continue to have? Or we need to rethink our IP strategy. We rewrite our IPR law. Should we become TRIPS plus and not TRIPS minus or TRIPS? What is the ultimate aspiration of our younger generation? We are all old. I don't think I can say I am old. I don't want to admit. But nonetheless, there is an aspiration for the millennium people in this country. We should respect them. What exactly they want. We can't impose our wish on them. So therefore, what is necessary is to rethink about the IP strategies, not necessarily on patents, on trademark, trade dress, on copyrights. This country was having the highest piracy few years back, a lot of years back. But look at our own Bollywood movies, Tamil movies. The aspiration today is IPR need to be protected, copyright to be protected. When more and more innovation take place in India, it does happen. It is the legitimate demand of the people, and the policy makers have to listen to these legitimate demands. And therefore, there needs to be a overall rewriting of the law, of course, within the parameters fixed by the TRIPS agreement. We can become TRIPS plus, but not necessarily TRIPS minus. Pravin mentioned about the judiciary, how it is evolving, and very heartening to see what's happening in Delhi High Court and Madras High Court and other places. It is not easy for disposal of 450 matters in a matter of last about 2.5 years. Remarkable, innovative way of arguments. Many times when I am negotiating the trade agreements in other countries, I have appeared to Supreme Court and other high courts from London, from Brussels and other places. It's all possible because technology, and India has embraced the technology so well. Other countries, including United States, are lagging behind. Digital payments, the highest in the world in India. And the innovations are taking place not necessarily in pharmaceutical software. And India is the capital of software in the whole world. And we have the least the patents in software. We got 3K. I think a time has come to think that what we need now, any law which is enacted in this particular any country, is what is the need of the society at that particular point of time. I think we need to rethink our own strategies and ambitions. I need to talk a little more, but I think she is already signaling. So I stop now, and we want to hear both the judges and what they want to say, because lawyers love their own voices, and they are really, really fed up with hearing voices of the lawyers. I think we should once in a while listen to the judges, because they only listen, they don't speak much except in the court, and they speak through their judgments and not through the speakers. And therefore, and I know both of them are eminent speakers, so therefore I curtail my talk, and then I am waiting for hearing both the judges. Thank you very much, Ganpati and judges. Thank you.
Thank you very much, sir, for your energetic words of wisdom to everyone, especially to the young generation present here. With this, I would request Honorable Justice C. Saravanan ji to come on the dais.
Dignitaries on the dais, off the dais, members from the fraternity, press, a very good morning to all of you here who have gathered here this morning. At the outset, I would like to thank the organizers of Global Intellectual Property Convention for inviting me to this August function and to facilitate this gathering. I'm indeed honored to be here this morning. The impact of advancement and the sudden widespread of electronic technology on the rights of artists is being debated worldwide. It tends to change the way we create and disseminate works of art and necessitates revision in legal approach to protect the rights of authors and artists. Thomas Hobbes, a famous English philosopher of the 15th century, in his social contract theory, had said that life in nature is nasty, brutish, and short, and is marked by competition, violence, warfare, insecurity, and unrest. His take on humans was influenced by his faith and early education in the church that humans are not what they should be. He said they are fallen creatures, and unless they had help from their community and unless they had the help from the ruling establishments, they tended to fall into disarray and hurt another. Thus, he said human came together and formed a social contract, formed a system of government to solve the discord among them. He said people came together and they sacrificed some of their individual rights to create central authority so that the central authority will maintain peace and harmony among the people. This negotiation was called the social contract by him. He said what people needed was a strong central authority, a strong central government. Most of the intellectual property law works on this same principle, except that it is codified in most of the countries, India particularly. He said that government arrangement works like a sea monster with tentacles wielding swords. He compared the governing authority to a biblical sea monster, Leviathan, wielding powers to discipline human conduct. He said the central authority had to be strong, which could be anything. It could be a monarch or could be oligarchy, but its power was derived from the people. It could control the people in various ways, like a tentacled sea monster wielding power. If it failed to solve, it was bad. Likewise, if the law failed to solve the dispute, it is a bad law. Today, the mankind is much more involved than what was the situation in the 15th century. We have in India constitution and the laws enacted are consistent with it. However, the emerging trend in technology, particularly in the field of AI, is posing a threat. Several vocations will obscure and become redundant. The drift for protecting AI-generated content is gathering momentum. Courts are finding it difficult to give protection on the ground of absence of human intervention. The degree of intellectual property protection afforded to new forms of electronic art will impact how AI-generated work is created, critiqued, and marketed. We live in this global village. Law declared, discussed, clarified in another country and in another jurisdiction are becoming relevant. Courts in India and as also other countries are looking at them in a symbiotic way, as we do. A recent decision by the Supreme Court of US held that AI does not create any intellectual rights in the work produced by the program, and neither does the inventor of AI. In this case, the US Supreme Court upheld the precedent that inventorship is only for humans. The court and copyright officers are viewing AI programs and AI-generated work in the same vein as that of a pen, that is, as a tool or a medium. Current trend is to hold that a pen is a tool of creation and not an author entitled to intellectual property rights. Only work created by human with originality will get the protection under the intellectual property regime. The existing copyright law stipulates that first owner of a copyright in a work is the author. In India's Copyrights Act does not specifically address AI-generated works or recognize AI as an author. How the term person in the Act is defined and interpreted will become relevant in coming days. And since, as of now, only natural persons have been recognized as authors, artists, etc. under law. Recently, while dealing with an issue as to whether AI can be defined as a person under law, Delhi High Court had said authorship can only be attributed to a natural person and a copyright could not be asserted without evidence of individual involvement. The court had refused to recognize the copyright claim over a computer-generated list because of lack of human intervention. This also takes the debate to the issue of originality as the source of information and prompts being fed by the humans into the AI system. The novel Frankenstein by Mary Shelley is a story of an irresponsible scientist named Victor Frankenstein who brings a creature into a life without considering all the repercussions that may occur. Victor was not prepared to face any challenges that came along with creating new life, and he failed to meet any of the needs of the creatures. Throughout the entire novel, the creature was given a negative connotation, but the reality of the situation of the creature was a victim despite any of the sinister actions that took place. The creature in Mary Shelley's Frankenstein lacks the social acceptance required to prosper as a functional member of the society. We are bracing to such a situation with the advent of AI interventions. The Frankenstein story serves as a thought-provoking framework for contemplating the impact of artificial intelligence on our perception of reality, knowledge, and the potential consequences of relying on and acknowledging AI-generated work. Programs like ChatGPT, Bard do not currently attempt to assert any IP claim on the work generated, instead passing all responsibilities onto the user. The same is said to be for prompts put into them. I hope the participants will get to speculate on these issues during these 2 days. There have been sweeping changes in the Trademarks Act 1999. A confusion, however, still prevails how the courts are to deal with the powers vested under Section 57 and 97 of the Trademarks Act 1999. Under Section 57 of the Trademarks Act, the power to cancel or vary registration and rectify the registration has been now reverted back to the High Court as it stood prior to the enactment of 1999 Act. The powers were conferred on the High Court under Section 56 of the Trade and Merchandise Marks Act 1958. This was deleted in 1999 Act after it came into force. Section 57 and 97 and rest of the provisions of the Trademarks Act now have been amended. Under Section 97 of the Trademarks Act, a procedure for rectification of the registration has been vested with the High Court for the purpose of Section 57. A provision similar to Section 110 of the Trade and Merchandise Marks Act 1958 is conspicuously absent under the new Act after the amendment, although the powers have been vested with the High Court to cancel or vary registration to rectify the trademarks. The power that was earlier vested with the High Court under 56 of the Trademarks and Merchandise Act has now been restored back to it after the abolition of the IPAB under the Tribunal Reforms Act 2021. Earlier, under Section 109 and 10 of the Trade and Merchandise Marks Act 1958, a High Court was vested with the power to make rule consistent with the Act as to the conduct and procedure for all proceedings under the Act before it. A similar provision is absent after the powers that was vested with the Intellectual Property Act Board under the Trademarks Act 1999 was taken away and vested with the High Courts. After the 99 Act came into force, a separate set of rules were framed for the appeals and applications before the Intellectual Property Appellate Board. Under the old regime, under Section 110 of the Trade and Merchandise Marks Act 1958, various courts had framed rules for judicial proceedings. For instance, Madras High Court had framed Trade and Merchandise Marks Judicial Proceeding, Madras Rules 1968. The Bombay High Court had amended its original side rules in 1957 by substituting with Chapter 33. The Calcutta High Court had also amended the original side rules. However, under the new dispensation, after the abolition of the IPAB and restoration of the jurisdiction back to the High Court, in the matters relating to rectification of trademarks and appeal and application against decisions of the registrar, powers have not been specifically conferred on the High Court to make rules. Only under Section 158 of the Patent Act 1970, High Court has been vested with the power to make rules apart from the central government to make rules under Section 159. Section 158 of the Patent Act is similar to Section 110 of the Trade and Merchandise Marks Act 1958. A similar provision is also available under Section 54 of the Semiconductor Integrated Circuit Layout Designs Act 2000. A similar provision to Section 158 of the Patent Act has not been provided under the new Trademarks Act 1999. Copyright Act 1957, Geographical Indications of Goods, Registration and Protection Act, Designs Act, and Information Technology Act. In all these acts, similar provisions are absent. Thus, only two of the enactments contemplate the powers on the High Court to frame rules for protecting the rights. The rest of the enactments, it is only the central government which is empowered to make rules. However, High Courts have gone ahead and framed rules. Delhi is leading. And it is heartening to see that more than 450 cases have been disposed in since 2 years. Madras has now followed the suit. But this gap needs to be addressed and rules will have to be amended. I hope the deliberations today will take it forward so that these gaps are filled in. I would also like to talk something about the power of the courts and the registrar to declare a trademark as well-known trademark. If you read Section 11(8) of the Trademarks Act, both the registrar and the courts are empowered to now declare a trademark as a well-known trademark. Justice Anita Sumanth had actually rendered a decision in Madras High Court wherein she had said once the mark is declared as a well-known trademark by the court, then question of an applicant filing an application under 124 did not arise. However, this matter has been now referred to a larger bench. Though my personal view is that once a mark has been registered, the registry has to register the trademark as a well-known trademark. Recently, the Delhi High Court has also held that there is no conflict between Rule 124 and Section 11(8) as both operate differently, and Rule 124 is for implementation and enforcement of the provisions of Section 11.8, enabling the registrar to include the already declared trademark in the list after its publication in the Trademark Journal, and that the procedure pertaining to inviting objection, etc., will not be necessary, and straightaway the registrar shall proceed to publish the trademark and include it in the list, subject, however, to verification, etc., relating to the authenticity of the certified copy of the judgment furnished and other administrative and procedural formalities. The Bombay High Court in International Society for Krishna Consciousness, Bangalore, ISKCON, case declared the trademark ISKCON as a well-known trademark, and that there can be no two opinions. Prima facie, once there is a determination by the court, the registrar will be duty-bound to make an entry in the register of the trademark, and that trademark, as the trademark is a well-known trademark. A registrar is not required to once again determine whether the trademark is a well-known trademark. The question of the registrar exercising power under 124 of the trademark rules would arise only where a fresh application is filed by an applicant for the first time to declare a trademark as a well-known trademark in TMM. Since such an exercise has already been carried out by the court, the question of payment of 1 lakh as a fees needs to be discussed. Only where a fresh application is filed, there could be a determination, and therefore the charges can be justified. This requires to be discussed and taken forward. Finally, I would like to also talk about Section 29(5) of the Trademarks Act. The law that has been settled under the old Act and the law which was declared in the context of passing off is now being passed off as an infringement. This matter needs to be discussed. I hope the delegates and the participants discuss and take it forward and bring it to the court so that matter can be settled at some point of time. Thank you for a patient listening.
Thank you, sir. We honor your words. As a compliance and legal professional, truly appreciate for the way you gave detailed insight into the various sections under law. Now the time has come to listen to the most awaited words of wisdom. I request Dr. Anita Sumanth to please come.
Justice Saravanan, Dr. Shri Agarwal, erudite speakers on the dais, too many to name, distinguished invitees in the audience, ladies and gentlemen, good morning to all of you. I know I have two disadvantages. One is that much of what I wanted to say has already been said by the previous speakers. And the second is I come last in line of several very good presentations. So I know you must be tired and waiting to move on to the next. I promise to keep this as brief as possible. Now, at the outset, I just wanted to respond to two comments that were made by Mr. Pravin Anand in the course of his address to you. And both of them touch on the theme of this conference itself. The first point he made was in the context of ways by which courts impose costs or find alternative ways to impose a cost on an erring party before them. And he gave you several innovative steps that have been taken by courts in this regard. I just wanted to add one to that, where in our experience there was a motor accidents claim that was filed. And the party that had caused the accident was a young driver of a two-wheeler who was not wearing a helmet. So the court there, they didn't want to impose a monetary cost on him. What they did was they asked him to take classes in driving schools on road rules. So you see there is innovation there also. And the second point that he made was on the measures that courts take to control the board before them. And in this context, he used the term rogue parties. His words, not mine. And see, in the Madras High Court, we don't have our rosters change every 3 months. And we don't carry as part heard. If you continue in the same roster, it's all right, because you can continue to hear a matter that you've substantially heard. But if you move on to a different roster, then our rules require that the two parties who have argued a matter substantially before you should give their consent to the matter being designated as part heard. So if there is, to quote Mr. Anand, the rogue party, who feels that he is not cut ice with that bench and would prefer to argue the matter before a different bench, you are not going to get a consent from that party. So, we have our own innovative ways of dealing such situations also. So what we do is, apart from recording the deliberations of the day, etc., which he referred to, we reserve the matter. We simply reserve the matter. Of course, assuming that it has passed beyond a particular stage of hearing, not inappropriately, we reserve the matter and then we list it for clarification later, if there are any gaps to be filled in. Now, I'm sharing trade secrets with you. I wonder what the implications of that would be. So now, when I was invited to this conference, I did wonder whether I would be a little bit of a trespasser, because though I had had a very interesting stint on the original side, albeit briefly, and I'd had a smattering of IPR matters thereafter, my core practice, our exposure, had never been in the domain of intellectual property. But coming to think of it, am I, or is anyone for that matter, really that much of a trespasser when you're looking at the intellectual property regime today? Our lifestyles and much of our days are fueled by so much of innovation, products of individual as well as collective creativity, that we are all touched by intellectual property day in and day out, repeatedly, continuously. So, to quote Edward de Bono, an American broadcaster and a founder of the very interesting term lateral thinking. He's the one who coined that term, lateral thinking. He says, there is no doubt that creativity is the most important human resource of all. Without creativity, there would be no progress and we would be forever repeating the same patterns. We hardly repeat old patterns today. Everybody is tweaking old ideas, innovating new ideas, though the sum and substance of what was presented by the earlier speakers is that there is just not enough of innovation that is happening, which is why we have conferences like this to fuel our minds and make us think. Our lives are a flux of fresh and new ideas that modify, often simplify, and sometimes, not always, improve. I'll skip over a lot of what I had put down in the interests of saving time, because I know that we have to move on to the subsequent sessions. The organizers have lined up some fantastic sessions before you that deal with cutting-edge themes like online gaming, metaverse, social media influencers, and artificial intelligence, apart from the time-tested subjects as well. On this, I just wanted to share an interesting anecdote with you. I found that non-fungible tokens are part of the, NFTs are part of one of the sessions that are technical sessions that you have here. We had a delegation of judges that traveled to Singapore recently, headed by the Chief Justice of India, and I had the good fortune of being a part of that delegation. And one of the presentations that we made there, one of the subjects that we discussed there was on the aspect of cryptocurrency. Cryptocurrency, which includes non-fungible tokens as well. So the theme, the manner in which we did it was the Singapore delegation made a presentation and we made a presentation to counter that. So in that, on their presentation in cryptocurrency, they had quoted Madonna. Madonna's Material Girl. So to rebut that, we quoted the English band Police. You know, the theme was whether cryptocurrencies should be regulated. How do we go about regulating the various kinds of cryptocurrencies that we have? So we said that we would follow what the English band Police had written. Every breath you take, every move you make, we'll be watching you. I think in many ways, that would, both the songs perhaps, would apply in the context of intellectual property as well. Undoubtedly, it's a material world out here. Everyone is fueled by commercial considerations in what we do. And how do we improve or increase innovation? I think we have to keep an eye open and see what needs to be done. The previous speakers touched on a very important aspect, which is our investment in research. And some of the figures were really unfortunate in that for a country of this magnitude, our investment in research is just a pittance. And we were, Dr. Agarwal and myself were just mentioning, and I will give him benefit for a quotation that he made as well in this context. See, we find that while monopoly is frowned on in most areas of the economy, intellectual property is one where individuality of thought and expression, generation of creative assets is encouraged and protected. So in this context, he said, innovation is inclusive and IP is exclusive. I'm giving you credit, no infringement there. And perhaps in this area, coming from a different perspective or a different angle from where you would come from, I would say that a balance has to be struck. Talk of compulsory licensing. I know it's a bad word around here. It appears to be a bad word because some of the panelists were just discussing compulsory licensing very briefly before we started the conference. And perhaps we are one of the few countries that have compulsory licensing in the world. And compulsory licensing would be anathema to a creator or an innovator, because what you want is to protect your idea in full. But where I come from, I would think that a balance has to be struck somewhere, particularly in the arenas of life-saving medicines. I read somewhere in the press that the Kerala High Court had recently issued notice on the process to be followed for compulsory licensing of a foreign life-saving drug for cancer treatment. So how this would play out, really, I think time would tell, and you as practitioners would have to be the thought leaders as well as the leaders to take this forward. One of the earlier speakers had made a comparison between today and maybe 20 years ago or 30 years ago, and how do concepts in intellectual property play themselves out today. There has been significant progress, undoubtedly, not just in how IPR concepts play out, but in many concepts. For instance, in litigation itself. Today, I would think that we are moving very slowly perhaps, but moving to alternate dispute resolution methods rather than a totally adversarial resolution method. So you look at mediation. I've always felt that alternate dispute resolution methods, particularly mediation and conciliation, arbitration perhaps not so much, would be one where it requires two very cultured parties to mediate. Because as contradistinguished from conventional litigation where you have a win-all situation, in mediation you have to be willing to give some and take some. So that sort of an attitude, I don't know how conducive it is in a forum like this. Perhaps I'll never be invited back. But I do believe that one should strike some sort of a balance even in a purely private, purely commercial domain such as this. We were talking of innovative steps, one of the speakers, and of course, I'll be bringing coal to Newcastle, but I think these concepts are very old concepts which started from Baker versus Selden, 1879 US case, and closer home we have R.G. Anand versus Deluxe Films. And coming from a taxation background, I wanted to share with you one unreported copyright judgment on copyright. You must all be aware of the two giants in tax law. One is Nani Palkiwala and the other is Sampath Iyengar. Anybody who has had any practice, Mr. Lakshmikumaran would know, the Bible in the offices would be the volumes of Chaturvedi Pittasarya, Sampath Iyengar, and Kanga and Palkiwala. So there was, Sampath Iyengar had written a commentary on the 1922 Act. And when the later commentaries came out by Kanga and Palkiwala, he felt that there were certain portions that had been plagiarized or there had been an infringement of those paragraphs. So he issued a notice on 22/11/1951, followed by the filing of CS 350 of 1951. Unfortunately, I was not able to get a copy of the judgment, but this suit was heard and dismissed by Justice Punjabi K. Shayyar. And to quote him, he said, "If any part of a work complained is a transcript of another work, or with colorable additions and variations prepared without any real independent literary labor, such portion of the work is piratical. It is impossible to establish a charge of piracy when it is necessary to track some passages and lines through hundreds of pages, or when the authors of a work challenged as piratical honestly applied their labor to various sources of information." Both of them went into the box. Both Nani Palkiwala and Sampath Iyengar went into the box. And in an article that was written, this is also finds place in a book on Nani Palkiwala called The Courtroom Genius. They say that Nani Palkiwala had conducted his testimony far better than Sampath Iyengar did, and Sampath Iyengar had been carried away by emotion. And an interesting observation that had been made by Justice Iyer in regard to common italicization and how Nani Kanga had highlighted the same paragraphs while using italic font repeatedly, the judges observed, and I quote, "Indians as a race are very fond of italicizing things. One well-known Indian statesman read a book 3 times, underlining 1/3 of the book every time. At the end, he found the whole book underlined. Indians thus have a great fascination for zeros and nils, and even call God Puja, or the Supreme Zero." I think I've taken too much of your time. I wanted to talk about one of my pet peeves, which is the rights that are asserted by creators of songs in cinematograph films, but that's for another day. I will conclude by quoting Maya Angelou, who says, "You can't use up creativity. The more you use, the more you have." And with this, issues and controversies that would arise from such usage. I have no doubt that a conference of this nature will answer a lot of the questions that run in our minds. I have a suggestion for the organizer, that you do conduct the conference over a weekend the next time and not on a Monday, so that we would have the benefit of all the technical sessions over a weekend. Thank you very much. My thanks to the organizers and also to Mr. Ramesh Ganapathy for this invitation, for his very persuasive invitation, I would say, which made sure that I am here. My best wishes for the conference and to all of you. Thank you very much.
Madam, we are speechless. No words can substantiate our feelings to appreciate you and your humbly spoken words of wisdom to everyone present in the hall today. With this, I request all of you to give a big round of applause to all our guests present on the stage. Thank you, everyone. Now I rest my speech here itself, and I request Dr. Ashwini to present a vote of thanks.
Thank you, Nisha. I extend my sincere thanks to all the distinguished speakers, participants, organizers of this remarkable conference. The insightful talks will really make this event very memorable. The theme this year is Innovate, Protect and Scale. So there is a thing on your card, if you go back to your identity cards, there is a thing says, let's talk about. We want you to put some keywords there so that you can initiate talks with everybody in the audience or the participants, and that would be the keywords where you can start the talk with. So that can be an icebreaker to introduce, and that is a theme which is Innovate. So this was an innovation from ITAG. So I cheer them up, and yes, we will do it. So my words are CSR and health. I just did naturopathy course, so anybody interested, that's my keyword. The second is a mobile app download, again on the behind of the card, that will give you the connectivity. You can connect and set up your meetings and also the updated schedule and the agenda. The third thing I want to tell you is there's a group picture which will be taken just before lunch, so please be at the site. Thank you all for sharing your knowledge and expertise and contributing to the success of this conference. So as Nisha said, your network is your net worth. So please network and increase your net worth. Thank you.